Good morning. We're going to start our new panel, Panel 9, Confidentiality and ADR Procedures and Public Interest and Access to Information. We have two guests to discuss this, to debate this topic today. I'm going to give them a quick introduction, and then they will present their different topics. According to the Regional SNCC Studies Program, a recent survey showed that 77% of Brazilian internauts are concerned about how their data is used on virtual platforms. If we reflect on this, we've seen a bunch of resistance and pushback from users when it comes to biometrics. The LGBT law entered into effect 2 years ago, and there is an understanding of the importance of protecting personal data. In the Center for Solutions for Intellectual Property, the procedure scopes for conflicts regarding domain names, we have seen requests for exclusion of personal data, removal of personal data under the data protection law. And a number of lawsuits have been brought on behalf of the SACI ADM. There is a clear concern for protection of personal data. For the extrajudicial mechanism for adjudicating these issues, we've seen that the LGBT law has been promoted, although it is not the pioneer in the field. There are other countries that have this law in effect. A number of foreign entities are also focused on this very important topic. And there is also concern about the data that is used and referred to in conflict resolutions. This problem can be seen both in Brazilian and international lawsuits. And personal data needs to be understood in terms of these extrajudicial conflict resolution forums. Sometimes it's just individuals that are involved. Sometimes it's individuals and legal entities. Confidential data can be included not just in the data, in the procedures and in the lawsuits, but that before the but as part of the proof and the evidence that is used in the lawsuit. And care needs to be taken at every stage of the process. Arbiters, specialists, and judges and institutions like our Center for Dispute and Resolution can be seen as controllers and operators of this data. In addition to direct participants, there are third parties that may be called in to witness or as expert witnesses in any lawsuit. And they also need to be aware of the importance of protecting personal data. We also have to be aware of international transfer of data. There are specific laws that govern this type of transfer of data. With the SACI ADM, we see that domain names and privacy regarding domain names is already regulated. There are a lot of conflict resolution resources available. Personal data can only be treated using the legal recourse. Title holders have access to their own personal data at all times according to the data protection law, the LGBT data protection law in Brazil. This is a very complex issue. It requires extensive analysis, and the concern in our country is rather recent, but it is widespread. So we had to break down the problem. We can't look at every single aspect. Obviously, that would take way too long. We only have 1 hour, and we're going to take a look at a few basic concepts. We invited 2 authorities that work on extrajudicial conflict resolution. NIC.BR, they administer these procedures, or these legal lawsuits. And they'll be talking about how the different authorities address these issues. Dr. Raquel Gata will be the first to speak. Thank you so much for being here. She is the head of legal NIC.BR. And she works very specifically with SACI ADM, so that's domain registration. She is the vice president of the Internet Society Brazil. She received her undergraduate and doctors in law at the PUC São Paulo. She heads the Internet Governance Forum. She has extensive experience, and it is great to have her here with us today, and thank you for all of your work that you do at NIC.BR. Thank you so much for this invitation to be with you today, and I'm happy to share our experience with you. I'd like to thank you for all your help with all of the procedures and all of the lawsuits that we see, all of the legal actions that we see. You've been such a partner with us. Dr. Manuel has allowed me to make a few changes to the presentation when it comes to implementation of the data protection law. Last week, NIC.BR held a privacy seminar, and we talked about data protection and the different statistics department and the data protection department within NIC are focusing on. And this research last week has been focused on 3 areas regarding implementation of the data protection law: users, companies, and government agencies. The idea is to work with evidence and data so that we can draft public policy for adopting and implementing data protection as a culture. So I have a bit of statistics for you, but please visit the privacy seminar website. There's a lot of content there, and I think it has a lot to do with our topic here. I know we're going to be talking specifically about domain names and SACI ADM, but statistics. When we look at users, just 25% of the users are concerned, or at least were concerned last year. This is research from last year. 25% were concerned about complained about use of personal data. So awareness is not as widespread as we'd like. That people are still unfamiliar with their rights. Another highlight for users is, I would say, security and hygiene, online hygiene, I would say, or online health. Many users said that they looked at the little lock on the top of a website and assumed that they were on a safe website. But very few people actually change their passwords to an alphanumeric password with a number of symbols. So again, this type of awareness and training is lacking. When we look at companies, the numbers are a bit more alarming. Only 17% of the companies that were surveyed have a DPO, a data protection officer. And only 32% have reported that they have some compliance policy that they've either designed or even implemented. So I think we have a very long road ahead of us. We've already implemented this, this policy, but it's very important to understand what the policies are that have been implemented successfully in the companies, and they should be replicated in other companies. And also for government agencies, we have some data from other CETIC data. These are surveys through our e-sites and through schools. We're actually quite advanced in terms of the data protection law. 94% of government of the courts are concerned about it. It's not the same in the other two branches of government, legislative and executive. I don't have the actual number. Legislative about 50+%-ish, and executive is below 50% in terms of implementation of the data protection law. So again, there's a lot of work to be done in those two branches. For the National Data Protection Authority and their presidents and their directors, they have reported that they will be using these data to draft and design future public policy. Okay, so that's just my little kind of side note here. But going back to my presentation now, let's talk about conflict resolution for domains under the SACI ADM. .br started in 1989. It was actually a research project initially, and the FAPESP organization embraced it, and it includes a registration of domain names, very basically, internet domain names. That's a very simplified understanding of what it does, but that's what it does. And then 95, there was the Internet Management Committee. Now, that is a public policy consulting agency on the use and development of these domains. This committee is very well known. It's basically the political head of NIC.br, NIC.br. That was established in 2002 and started operating in 2005. So let's consider from 2005, NIC.br was finally established as an operational arm, an NGO operational arm, as the agency responsible for registering .br domains. And it was established before the PAPES organization. Okay, let's talk a bit about the institution. We first started focusing on domain conflicts or controversies related to domain registration. If there was no resolution, and we thought this through with the community, with ABPI and other partners, we established an administrative conflict resolution department. First regulation was established in October of 2010. We've had 586 lawsuits that have been brought to us, or conflicts that have been brought to us. Okay, so it's 600 actual lawsuits less, because this is just conflict resolution. So it's 600 fewer lawsuits in the court system. Normally, it's the title holder that will file a complaint, but it's actually the other way around here. So normally the complaint needs to be filed by the person who owns the domain, and this is just the opposite now. Decisions are made in approximately 90 days, which is actually very few days when we look at court and lawsuit. decisions. And it's actually the complainant, what would be like the defendant, who has to file the complaint, basically in this case, and has to respond to this complaint. So we've seen quite successful and very efficient conflict resolution. I can talk a little bit about SAC-ADM. I'll talk about that more during the question and answer period. Sorry, whoops, I jumped forward a little too quickly there, but I just wanted to show this. What our concerns were when we mapped out the LGDP, which is the data protection law in Brazil. So how does this work? The complainant, if there was bad faith, whether it's your company name, whether it's your domain name, whether it's some prior law right that you have that can generate confusion, that can lead to some sort of damage, you can use one of the accredited organizations. That's SAC-ADM, ABPI, WIPO. They also have a chamber. And the Brazilian Canada Arbitration Chamber. All of those are legitimate organizations. So the claimant or the complainant has the right to appeal to one of these organizations. And then NIC.br has to report on this domain. It has to report that this procedure or this arbitration was filed, and nobody else can touch this domain. And with that, the demandant or the defendant has to basically come up with their response to that. We then send the information, all the information on the domain title holder, the domain holder, about the arbitration process. It's right here at this very first step where we identify what the personal data involved. Again, there has to be an individual behind this. 30% of the domains have this individual. Just to give you an idea of numbers, but 30%, that's 5 million names. That's 5 million individuals behind the names of .br. This is one of the largest domains worldwide, domain holders worldwide, but only 30% are individuals. So when there is a procedure involving individuals, we first look up what the information that has been reported is. As part of the complaint, we look into the complaint, we look into the information in NICBR and with the arbitration chambers. And we look to see if there are any sensitive data. For example, publication of the parties' addresses. We don't need this type of information published. We just need the absolute minimum to identify the parties. Second stage, we wanted to understand the legal basis. What are our legal grounds based on the data protection law? One, it's a contract. When you register your domain in your name, you sign a contract wherein, and this has already been updated to reflect the data protection laws, but in this contract, you agree to the publication of some basic data and agree that some of this data will be used. Your name, your tax ID number, your contact information, all of this is published, openly published. And the reason is that this is public interest. If there's some sort of security breach or if there's some sort of irregularity, some sort of violation, this information needs to be readily accessible. Now, there are some that may be excessive. For example, your address, or based on your taxpayer ID, you can list all of the domains in that person's name. Now, in some exceptional cases, through some sort of legal requirement or legal order, court order, government order, this may still be published and accessible, but otherwise we keep it anonymous. We look at this contract with the title holder and the SAC ADM information, and we look again at the legal basis. What are the public interests in this case? Then we draft a compliance plan. We drafted a compliance plan. Okay, so those of you who aren't familiar with the new data protection law, spoiler alert, NIC.BR and the arbitration chambers understood what was done, what we can minimize in terms of publication of personal data, and what are the legal actions that we're going to take. In addition to collecting just what is absolutely necessary, we also have decided to pseudonymize the information. We're giving everyone a pseudonym, basically. So we want to minimize the amount of information, right? So we want to basically black out the information of the claimant and of the defendant. We basically only want their representatives listed. So this has been a concern of ours. So again, we give everyone a pseudonym or we anonymize them, and this is a practice that we have focused on since the very beginning. We want transparency in these decisions, but we also want protection. We want this to be established as a parameter for future cases, for jurisprudence in general. And so our intention has always been to be transparent in publication, but again, limit the exposure. So we established a new law to include this protection. And we also took this opportunity to make a few adjustments in the new law. It includes more techniques. So the new law, new regulation is already included on register.br. It goes into effect October 1st. So it was published August 1st, and it enters into effect October 1st. So there's a little bit of time for adaptation. Cases that were filed before August 1st will continue with the old standards. And then we also have the stage of training, monitoring, and publication. We train, we get monitoring, we get feedback from people to see if this is working. I think in the previous slide I talked about some of the things in this slide, but this is just one highlight here. This is some of the, again, giving pseudonyms to the parties involved in the decisions. Again, we want the minimum amount of data published, but we still want the basis of the decision. We want the final ruling published. I'd be remiss if I didn't mention also the WHOIS directory. This includes all identifying, the minimal required identifying information, title holder, taxpayer number, basic data name. Again, the reason for this is because of public interest in accountability in the case of any security breach. And of course, it's important to make a distinction between individuals and legal entities. 70% of the domains are legal entities, and so this information regarding private information doesn't hold for these legal entities. Again, they're not individuals, so we don't have to worry about data protection in that case. So we get all excited. We want to share all the data possible, but obviously I couldn't share everything with you. I hope there are lots of questions, and I'd like to continue working, and we want to take these questions as feedback so that we can continue improving our product. Thank you so much, Dr. Raquel Gatto. Thank you so much for your presentation. Just two quick comments. something that's already on the nic.br site is that there's a new regulation, new law. Okay, so it's going to go into effect in just a few days. This is the new data protection law. It has already been published, and you brought this. I just want to stress how important this is. So October 1st of this year. Second, I want to talk a little bit about our experience. It's an opportunity to congratulate nic.br for all of the work you've done on updating the data protection law. We are accredited, and nic.br has been seeking us out to follow along with them in this adaptation process, in this adjustment process. And we were asked to update and adjust our procedures based on what we saw you doing and include them in the nic.br procedures. So we have nearly completed this internal adaptation process, and we've included the tools that nic.br has asked of us. And now we're adjusting to the law. So this is very important, and I wanted to invite you all to do the same. We're kind of in this in-between period between the old law and the new law, but it's important to update our conflict resolution process, the internal conflict resolution processes, and make sure that we're all aligned with nic.br. I'd like to ask you all to ask your questions at the end of the end of this panel, because we have a second presentation now. We will have time for questions and answers at the very end, for those who are online and for those of you who are here in the audience. I'd now like to invite Dr. Verena Mora Weisberg.
Thank you so much, Verena, for accepting our invitation to be here. Dr. Weisberg is the Deputy Counsel of the ICC, which has a branch or a chapter here in Brazil, in São Paulo. Dr. Verena Weisberg holds a degree in law from the University of the State of Minas Gerais. She's also a Master of Law, and she is an attorney here in Brazil, and she is also an attorney in the United States. And she is enrolled in the Bar Association of New York, and she specializes in dispute resolution in commercial contracts. Dr. Weisberg, the floor is yours. Thank you very much, Dr. Emanuel, for inviting us to be here. And I would like to thank our audience for being here, both here in person and also online. I would like to start by giving you some context about the International Court of Arbitration of the International Chamber of Commerce. And I think it is important to give you some context because we have many ADR centers specializing in intellectual property. So I would like to bring you closer to our context. So to do that, we should understand that the court was founded in 1923, and it has heard over 27,000 cases. We have members of over 116 countries, and our headquarters is in Paris, but we also have offices in São Paulo, Hong Kong, New York, Singapore, and Abu Dhabi. Also, with the goal of providing you with some context in our conversation today, I would like to talk about the sectors of the economy that we cover. The data that you see on the slide are based on the cases filed in 2021. Although the main sectors are still construction and engineering and energy, we still have many cases involving IP, especially when it comes to healthcare and life science, entertainment, telecommunications, specialized technology, and media and publicity. So as Dr. Gatto said, it is very important, of course, to bring some context to our audience. Also, about the cases heard in 2021, almost 6% of the cases were based on IP contracts. These are IP disputes, and most of them are related to licensing, trademark, and patents. Although we're not specialized in IP in the ICC Court of Arbitration, this is a very important topic for us, and it is increasing in importance. And now to talk a little bit more about confidentiality in arbitration and other ADRs, I would like to give you an overview about how we deal with confidentiality in arbitration cases here in Brazil and also internationally. Confidentiality is a general rule, but it is not provided for in any law here in Brazil. And specifically, it is not covered by the ICC rules either. So confidentiality is a possibility in arbitration cases, but that's not necessarily the case in any arbitration rule. For example, the rules of the International Organization for Arbitration, it has Articles 75 through 78, providing for confidentiality as a rule, but that depends on the regulation of each entity. As for the ICC, confidentiality is a possibility, not really an obligation. And confidentiality really depends on the will of the parties. It is usually provided for in the contract itself and arbitration clause expressly or because of the regulations of the venue where the arbitration will be heard. And of course, it is one of the benefits of arbitration procedures and other alternative dispute resolution procedures. When it comes to the public interest in access to information, and specifically about the Brazilian legislation, there are many exceptions to the confidentiality rule, and they usually relate to arbitrations involving government agencies. So any arbitration procedure involving a government agency has to obey the principle of publicity. And that, of course, leads to the issue of publicity versus privacy. And I'm going to talk more about that later. Another interesting exception, which is more recent and relates to the regulatory aspects, was the Brazilian SEC regulation number 21, which talks about the arbitration procedures that may impact the company's economic or financial situation. This does not necessarily mean that an arbitration involving a publicly listed corporation will not be confidential, but the existence of the arbitration procedure should be disclosed to shareholders. So this reveals an increasing concern about the public interest in access to information in comparison or versus confidentiality. And Dr. Gatto already talked about data protection in the context of arbitration, but I would like to bring this to the context of ICC. As I said, ICC is headquartered in Paris, and the Brazilian data protection law did not bring many changes to our practice because ICC already had a note based on the GDPR, which is very similar to LGPD, the Brazilian data protection law. And it applies to all ADR procedures, including arbitrations held in ICC, including in offshore offices. And that includes, of course, São Paulo, in everything that is compatible with the local legislation. And in our case, this rule is 100% compatible to the local legislation, which is the LGPD. So we did not have to make recent changes to our governance policies because of that. Another old concern related to the GDPR, which came before the LGPD, is related to the fact that we have a template policy for data protection so that the parties can use that template to address data collection outside the context of the institution managing the arbitration and also the arbitration tribunal. And now talking about the public interest in access to information, and of course that goes way beyond the regulatory aspects of the topic, I would like to talk about the private aspect. Since 2016, the ICC has been publishing information on its website, and of course there are other very specific aspects that we should talk about. Since 2016, the ICC has been publishing the names of the arbitrators, their nationalities and roles in the tribunal, and also the status of the arbitration procedure, if it is ongoing or if it has been completed. And in most cases, in most arbitration cases, they are confidential, but still in confidential procedures, when there is specific consent by the parties, we publish that information. For example, the content of the arbitration and the amounts involved, they are kept secret and confidential. But in some cases, we can use that information in the creation of case law, for example, or for statistical purposes. But we have to make it clear that in confidential cases, it is subject to specific consent. And even in cases that are not confidential, the parties are informed about this and they have the opportunity to object to this type of publication. Since 2020, when we expanded the types of data that are published, we have not had any issues related to that. And now let's talk about the publication of arbitration awards. And we can talk about the case law, arbitration case law, which is an old topic that we have been tackling. And since 2021, the ICC has been publishing the awards upon specific consent by the parties in the case of confidential procedures, and also their consent about the content of the publication. So the awards are usually anonymized or pseudonymized, and we can also hide parts of the text that can allow for parties to be identified. And we need to wait for 2 years until we can publish the awards to avoid any problems with the execution of the award. Another interesting aspect is that the awards are relatively accessible. Since 2021 and the awards that have been passed in 2019, many awards have been published and they are accessible by anyone because of a partnership that we have with Jus Mundi. So I think this is an initial step towards, balancing the public interest against confidentiality, which is absolutely critical. And one of the main assets of ADRs, whether they involve IP or other sectors, usually the companies involved are concerned with reputational issues and market value issues. So we can see that the market has been increasingly concerned about this, and they have been leaning towards these procedures and not court cases or court lawsuits. So with that, I would like to finish my presentation and turn it over back to Dr. Manuel. Thank you very much. Thank you. Thank you very much for your presentation and the very valuable information that you brought to us about arbitration procedures under the ICC. And now I would like to start our Q&A session, and I would like to invite our audience to take this opportunity and ask questions to our guests here, Dr. Gatto from NIC.br and Dr. Verena Weisberg from the ICC. I believe that we should also take questions from our online audience, right? And let's start with our audience who's here with us in São Paulo. So please, if you would like to ask any questions, go ahead. Well, I think your presentations were very clear and did not leave any room to questions. But I would like to take this chance and the time that we have here to ask a few questions. One of them is related to something that I mentioned earlier, which is the growing importance of protecting personal data. And that applies to individuals and not to legal entities. Here in the ABPI, we have received requests to exclude personal data because in the beginning we did not use anonymization or pseudonymization in the awards and decisions, but now it seems that NIC.br is starting to use pseudonyms in all decisions. So I would like to know from you, Dr. Gatto, what is your perspective about the use of pseudonyms in the 400-plus decisions, as you mentioned in your presentation? So we are not only adjusting to the data protection law from now onwards, but also looking back. And I would like to know how long is it going to take to do that job and pseudonymize all those decisions? Well, thank you for your question. After the rules were approved and published, we started the process of using pseudonyms in the decisions that had already been published, and there are 410 of them. I said 586 decisions in my presentation, I believe, but if you visit nic.br, you are going to see the decisions have not been published since January 2022. And we did that because we knew we were going to start that process. We believe that before October or maybe in the coming weeks, by the end of August or the first week of September, I believe that we will have already republished all of those decisions, having replaced or anonymized all personal data, and the accredited institutions will forward those decisions to us, and we are going to work together with them to publish the decisions after the pseudonymization process. We should think of nic.br as an institution or an entity that is concerned with domain names, of course, but also with the compliance policies related to personal data. We started to raise awareness about compliance policies, and not only that, but we have also designed compliance policies with each department, including the CETIC, the Center for Studies on Information and Communication Technologies, because those departments also collect personal data in their work. So we are concerned about that as well. We are concerned about our own departments and offices. The data protection law also created that culture of protecting the data that we collect, and we also are now more aware about the fact that we have to collect as least information as possible. We also have to think about how we are going to process that information. We are also going to obtain ISO 27001 certification to make sure that our internal processes comply with the regulation and follow all the necessary steps under the new law. One of the major contributions from the LGPD, in my opinion, is exactly related to how we are supposed to process data since the very collection of data. And that, of course, require the organizations to adapt their processes to the new law. Because in the beginning, we were not really thinking about why we were collecting the data. So now we have to think about the data that we collect in terms of collecting as least data as possible and not really exceeding the necessary amount of data that we should collect. In the beginning, we were also concerned about the publication of decisions because, as Dr. Weisberg said, it is important to publish the awards so that we have precedents to work on, so that we have a robust case law, and so that lawyers can provide better legal basis in their petitions and in their cases. Do we have any questions from the audience? Hello, good morning. My name is Luisa Tungari. I am an IP lawyer. First of all, thank you very much for the great presentations. This is a topic that is particularly interesting to me. I am an attorney, and as you said, it is incredibly important to us lawyers to have access to the decisions. In some cases, some chambers and companies hide everything, not only personal data, but the decisions themselves. So one important topic that I would like to know your opinion about is related to the confidential cases. Would it be possible for us to have access to the decisions or the summary of the decisions without any names of the parties, but the topic, the subject matter of the cases for statistic purposes, for example? It is interesting for us to know if the case is related to IP or domain names. The ABPI chamber has been doing that. We can have access to the summary of the decisions, and that is of great help to us in our research. So I would like to know if you are thinking about that. Maybe you could publish the summary of those decisions in the future, and that would be very helpful. Thank you very much, Luisa, for your question. Well, at the ICC, and as any lawyer, I have to say that it really depends, because in some confidential cases, publication is subject to the parties' consent. And sometimes we receive requests from third parties asking access to parts of the awards. It is not rare for us to receive this type of request. And what do we do in that situation? Well, we have to ask the parties. And some parties give consent to publish a summary of the decision and some documents, but not the documents that are part of the arbitration itself. And if we do not have consent, we cannot publish those documents. And in some cases, the arbitration is 100% confidential, meaning that the very existence of the arbitration procedure cannot be revealed or disclosed. Okay, well, you asked about the publication of the domain names at nic.br. We publish the content of the decisions, and that makes it easier for people to identify the precedents and the legal basis of those decisions. And there are only 3 types of decisions that can be passed under the SACI ADM system. the transfer of the domain to the plaintiff, or the cancellation of the domain name, or the transfer of the domain name from the plaintiff to the defendant. And usually the cases revolve around transferring the domain name from the defendant to the plaintiff. There are some cases that involve family names and other rights, other IP rights. And in those cases, we can make that distinction. But I believe that we are going to continue publishing the awards because of the public interest in the decisions that are passed under the SACI ADM system. I was thinking about a potential conflict with confidentiality. Sometimes documents are brought to the arbitration court, and witnesses' depositions, sometimes they include personal data, but under the LGPD, the data subjects have the right to know, and they have the right to access the information that is disclosed about them, and that may cause problems in relation to confidentiality of the arbitration procedures. So I have a question for you, Dr. Verena. In Europe, they have the GDPR, which is much older than the LGPD. Has there been any problem related to that in the ICC arbitration chamber? No, I don't think we have had any problem related to that. And I was talking to my colleagues in Paris about that before our panel. So the answer is no. But this is certainly a very interesting issue, because when we think about arbitrations, major corporations come to mind, obviously, but there are other people involved in those procedures. Very often, individuals are part of arbitration procedures, and there are other players, for example, shareholders and witnesses, third parties. So we process personal data for sure in those cases. In our disputes, whenever we publish documents or awards, we have to contact all people involved. But we have not had any conflict in relation to the LGPD here in Brazil. We have never had any external complaint about the publication or processing of personal data in other countries either. During evidence production or evidence discovery phases, confidential documents may come up, and the data subject of the data, the personal data included in those documents, well, that person could question how their personal data is processed. And for me, that creates a conflict when it comes to confidentiality. And that really shows that we need to have protocols in place to treat or process personal data. And we also need the commitment of all involved in the cases. And that is actually at the core of NIC.br. Sometimes the procedures involving domain names are simpler. We sometimes don't have the discovery phase, but in major arbitration procedures, that can happen. So we need to think about what we have to do in practical terms to comply with the LGPD. We need to adopt a number of mechanisms so that we are not taken by surprise. Absolutely. At nic.br, we have 3 documents that ensure users that we are complying with the data protection law. We have our rules, we have the data policy, and we also have a policy about how SACI ADM anonymizes or pseudonymizes personal data when we publish the decisions. In the past, before we adapted our rules to the LGPD, the data subject could look for their names and obtain a list of the domains in their name, but now we changed how it works since we implemented the new rules. And as I said in the presentation, there are just a few exceptions, for example, court orders. And in the procedure for evidence discovery, if the experts believe that they need that list of domain names registered under someone's name to understand exactly what the conduct was, that list can be submitted upon the execution of a confidentiality agreement with the chambers. So we do have that concern. We need to balance out confidentiality against ensuring that the necessary evidence is discovered so that the arbitrators or judges can make their decision. Absolutely, and the parties involved need to sign a confidentiality agreement, and they are ensured that the process follows the LGPD. Now, Dr. Weisberg. Yes, just to Dr. Gatto's point, even in the cases that are subject to publication, in the arbitration cases that are not 100% confidential, we need to think about privacy and publicity. In some discovery phases, we need the intervention of third parties, but we do not disclose their personal data, and that's probably why we have never had any complaint about that. And in some cases, confidentiality takes a secondary role. In some cases, under the LGPD, we need to respect confidentiality, but at the same time publish the necessary information. You mentioned the list of domain names, and some lawyers complained in the past because we were able to identify the number of domain names in a person's name. And now with the restrictions and constraints, that's not possible any longer. At least now we have that possibility. Now experts need to request that information so that they can make their decision based on that element. Do we have any other questions from our audience? I believe that we are running out of time. I believe that we don't have any more questions from our audience, and I don't have any questions either. I don't see any questions from our online audience. So with that, we are going to wrap up our panel, and we are very punctual. We are finishing right on time. So thank you once again very much for accepting our invitation, Dr. Raquel Gatto, Head of Legal at NIC.br. The information that you brought to us today were extremely helpful, because now we have significant changes being made to the SACI ADM system. And thank you very much, Dr. Weisberg, for bringing your experience at the ICC. And we know that the ICC has lengthy experience about this because the GDPR is much older than the LGPD. And thank you very much for being here with us. Thank you. Bye-bye.